Good evening, this is Jennifer Signieri coming to you live from my home, and this is Workers' Compensation Talk. This is Johnson & Groninger's Facebook Live format where we address your workers' compensation law questions and explain the answers in a way that is simple, helpful, and useful. The area of workers' compensation law to be covered in each episode varies, but the format is always the same. We talk about a given area of workers' compensation law. You're welcome to post your questions in the comment section. I have a computer right here where I'm monitoring questions, and we'll discuss them while we're discussing the topic. If you can't make it to today's episode, we'll go ahead and see the question even after the fact and answer it. The Facebook Live format was really born out of Johnson & Groninger's love of empowering workers' compensation, or empowering workers through the workers' compensation process. So to that end, if you know anyone who might be interested in today's episode, please do them a favor, post their name in the comments or post it to your profile page, and be sure to like our Facebook Live, our Facebook page, so that you can get notifications about future episodes. Before we get started, I want to give the obligatory legal disclaimer. Today's episode will be general legal information. It's not meant to be legal advice for a particular case or claim. But if you do hear something that triggers more questions and you want to have a one-on-one consultation, you are welcome to call us. We do provide free consultations at 919-240-4054. I'll put that on the bottom of the screen. Or if you are tech savvy and prefer, you can go on our website. There's a contact form on our website at jglawinc.com, and we'll call you. So that's just something to be aware of. Today's episode is about workers' compensation law and retaliation. I am a board-certified workers' compensation specialist, so I do hear a fair amount about retaliation in pursuit of workers' comp claim. I often hear from folks who come to me in confidence after they've been hurt on the job that even though they didn't ask to be hurt on the job, they really don't feel comfortable filing a workers' compensation claim, or they don't feel right about getting an attorney to help them get the rights that they so rightfully deserve. They have questions like, will I get fired, for filing this workers' comp claim? Will I be fired for getting an attorney? And these are very big concerns, legitimate concerns. So during today's episode, I'm going to cover three things. I'm going to talk about the North Carolina Retaliatory Employment Discrimination Act, RETA for short, and what it covers. Second, I'm going to talk about the steps a worker has to take in filing a RETA complaint. And then I'm going to wrap it up with a tip of the week. So first, although, and I think a lot of us know this, North Carolina is a right-to-work state, employers may not retaliate against employees who either file a claim or initiate any inquiry, an investigation, inspection, proceeding, or other action, or testify or provide information to any person with respect to a workers' comp claim. And this is not some made-up phrase I'm using. These are actual words in the North Carolina Retaliatory Employment Discrimination Act, or RETA. So what I've just listed off for you, as I said, is directly from the statute. And RETA, what it seeks to do is it protects a worker from retaliatory or discriminatory employment action such as termination, suspension, demotion, a reduction in wages, or even being relocated as retaliation for pursuing your rights under the Workers' Compensation Act. So, and I'll also say, as an aside, RETA protects workers who are reporting workplace violations or providing information regarding violations. So some straightforward examples of protected activities under RETA would include things like filing a workers' compensation claim with the North Carolina Industrial Commission, which is, of course, the state agency that oversees workers' compensation claims, or initiation of an internal investigation or completion of a work-related accident report. I think we've all, well, when you've been hurt in the job, asking for a work accident report is sort of part of the process sometimes. Even threatening to file a workers' compensation claim or complete a work-related accident report is protected under RETA. So, and to that end also, obtaining an attorney because you are filing a hearing request to get your rights under the Workers' Compensation Act is also protected under RETA. And this isn't by no means an exhaustive list. These are just sort of the more prevalent general examples of protected activity under RETA. So if a worker can prove retaliation in violation of RETA, some of the remedies that one could be up to get would be reinstatement of a job if they lost it, obtaining compensation for lost wages, lost benefits, and if a court later finds a willful violation, the court can triple the amount of the awarded benefits lost and require payment of attorney's fees. So that's this law really has a lot of bite to it, or it has the potential for a lot of bite. Some types of evidence that will support a RETA complaint include the closeness in time between when that retaliatory action took place and when the filing or the initiating of an inquiry into a workers' compensation claim happened. So the closeness in time is pretty relevant. I mean, it stands to reason that if you're a good employee and then you are fired the very next day after you're hurt in the job and ask about filing a workplace accident report, something is amiss. And it doesn't take too much of a Sherlock Holmes to figure out that the closeness in time between those related events bears some looking into. So some other things that are going to support a RETA complaint are things like statements from your supervisors or boss. Things like, "You're not going to fall again, are you?" Or a statement like, "You haven't done anything but cost the company money." So these are sorts of the activities that RETA is meant to protect, and against. It's also meant to have the worker know that they can feel confident in pursuing their rights without fear of retaliation. And to my second point, it's probably obvious, but RETA can be brought by employees or of an individual, a company, a partnership, an organization, a governmental entity. You cannot be an independent contractor. However, and maybe not so obvious, a complaint can also be brought by a person who causes a workers' compensation claim to be initiated or pursued on behalf of another employee. That is within the scope of RETA as well. So it's pretty broad in scope in terms of not just having the employee who actually suffered the workplace injury. So when a complaint is initiated, it must first be brought to the Employment Discrimination Bureau with the North Carolina Department of Labor. And the law actually requires workers to go through the North Carolina Department of Labor before filing a lawsuit in court. So, bear that in mind, that you're going to have to, bring the case first to the Department of Labor. For violations related to the Workers' Compensation Act, the Employment Discrimination Bureau has a questionnaire and a form that they want filled out and signed in bringing a RETA complaint. And you can get a copy of that form and questionnaire by actually calling their phone number, which is 1-800-NC-LABOR, LABOR. Also, a very important aspect of RETA, probably the biggest point, is the form must be filed, and that means actually received by the North Carolina Department of Labor within 180 days of the date of the last retaliatory or discriminatory act taken by your employer. So 180 days is roughly 6 months. It's not a lot of time, in the big scheme of things. And that time can go fast, and if you sit on your rights and you do nothing, you will not be able to bring a RETA complaint later. It's probably the number one bar I see to bringing a RETA complaint is sitting on your rights and doing nothing for 6 months. So once the Department of Labor has a RETA complaint form, it begins its investigation, it gathers evidence, and then it makes a determination based on the evidence it's gathered and obtained. And if the Department of Labor finds that it doesn't have enough to make a finding that retaliation or discrimination occurred, it gives a worker something called a right to sue letter. And these are actually fairly common. And they have, you would have 90 days after that letter to file a lawsuit in court. It probably goes without saying that if you believe that you may have a viable RETA complaint, you should consult with an attorney, not just about filing a lawsuit in court, but also in helping filling out a form, because you want to make sure you get everything all in there and improve your chances of finding some sort of merit from the Employment Discrimination Bureau. So a tip of the week, a lot of RETA complaints are based on circumstantial evidence. That is, it's a pretty rare case where somebody is hurt on the job and an employer says, you just want to get money out of me filing a workers' compensation claim, and then they're fired. Those cases do exist, but it's pretty rare. And so oftentimes what is actually happening is that an employee may be fired for some other reason that looks legitimate, but it's really a cover-up for retaliation for filings or pursuing rights under the Workers' Compensation Act. And so, some things to consider prior to or right after you're considering whether to bring a RETA complaint is to gather your evidence, the evidence you need. And that can include emails, voicemails. It can include writing down a timeline of events, specific words that were said by a boss, gather witnesses who might have heard the same statement. Gather as much as you can to build your case. I mean, you want to show that the basis for the retaliatory action taken is a cover-up or an excuse for the real reason, which is pursuing the claim, workers' comp claim, and your rights. So that's all for now on today's episode of Workers' Compensation Talk. Join us next time. Bring your questions. This is Jennifer Signieri with Johnson & Groniger in Durham, and have a good night.